Hello, and welcome to part 2 of our lecture for the day, where we'll be discussing the first part of Chapter 3 on condominiums. Tomorrow we'll finish up Chapter 3 with cooperatives and timeshares, and we'll then begin Chapter 6. Upon completion of this chapter, you will be able to define condominium, understand cooperative property ownership, and discuss timeshare arrangements. Condominiums did not exist in common law. Therefore, they have been created by statutes. The laws that govern and define condominium ownership have been developed by each state and are both statutory and contractual in nature. When you buy a condominium, you are purchasing a share of the entire building, with your unit or condo being yours in fee simple. If there are 35 units in the building, then you own a 1/35th share of the building, but you own the entire condominium unit that you purchased. Typically, there are fees involved with general building maintenance and upkeep of common areas. These would be similar to a homeowners association, where your fees go towards things like paving roads and parking lots or maintaining tennis and basketball courts. Documents needed to establish a condominium are the master deed, declaration of condominium, bylaws, articles of incorporation, purchase and sale agreements, plats and plans, map, rules, and regulations. So the person or entity that develops the condominium must prepare a comprehensive set of contractual covenants, and that is known as the condominium declaration that governs the condominium ownership. The condominium declaration sets forth the specific rights and obligations of each individual condominium unit owner and controls the governance of the condominium. I'll talk some more about some of these instruments, but you can also find definitions for each of these instruments in your books. The developer must also prepare a plat description that shows the size and location of all individual units. The plat description will designate all common areas as well. Plats are not only for condominiums, but if you own your property, you probably have a plat attached to your deed that shows the boundaries and borders of your property lines. You certainly have one if you live in a subdivision, because as we discussed earlier in the course, subdivision developers must also file similar documents as condominium developers. You can go to your local courthouse and look at the map books to see plats of various properties. Some of these are also available online. The following 2 slides contain information about what goes into a condominium declaration. You may also turn to page 35 for a listing of what a condominium declaration must contain. They must contain the name of the condominium, a legal description of the entire real property that is to be the condominium, description of all common areas, creation of a governing body for the condominium, limitations or restrictions on the power of the condominium. And here are some additional items that you would typically see in the declaration as well. The allocation of a share of liability for common area expense to each condominium unit. So this is, as I said, if there are 35 units in a building, you own a 1/35th share of the building, meaning you would pay 1/35th of the liability insurance. A statement of all restrictive covenants in the general use of the units in common areas. So a common area, maybe there is a pool at the condominium, and the restrictive covenants might say all children under the age of 12 must be accompanied by an adult. A description of how the condominium can be expanded. That way they're not just going to start throwing up buildings without the permission or vote of the owners, and a statement of how the condominium can be terminated. The Homeowners Association is formed as a nonprofit corporation with each individual unit owner having one vote in the issues concerning the homeowners association. Since the homeowners association is a form of corporation, in order to be legal, it must file articles of incorporation with the Secretary of State in the state in which the condominium is located. The articles of incorporation lay out the basic positions for officers like the president, vice president, treasurer, etc., and their power to oversee the association. It is very important to draw up clear bylaws, rules, and regulations to prevent an abuse of power or a situation where the homeowners association fails to carry out its duties. Here are the specific criteria that must go into the articles. They usually include the name of the association. So the association of the subdivision where I live is Pleasant Hill Subdivision Homeowners Association, da 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 da. The purpose of the association. The purpose of this association is to administer the covenants and rules and regulations of the condominium building. Period of duration for the corporation, the initial directors of the corporation, registered agent and registered office of the corporation for service of process. Service of process means that is the place where if somebody sues the condominium, that is where they would send a copy of the lawsuit to be served or have service of process accomplished. And the criteria for becoming a member of the association and the name of the initial incorporator. Bylaws, remember, are optional when filing the articles of incorporation, but any good business organization will develop bylaws, whether they are filed with the state or not. And typically, the bylaws will be filed in the courthouse along with the covenants and rules and regulations. Question: is there a requirement that bylaws must be filed? There is no requirement that bylaws must be filed. Just remember that. Articles of incorporation must be filed. Bylaws are not required to be filed. Bylaws must be adopted by the homeowners association and provided to each owner whether they are filed with the state or not. So that's the importance of the rules and regulations, where do the bylaws have to be adopted by a majority of the homeowners, or a supermajority, 3/4, or 100%, which would almost never happen, but there are instances where that might be the case. The bylaws of a condominium govern the day-to-day operations of the complex and typically include the items on this slide. The assessment is used to pay an individual unit owner's share of the joint liabilities, which is the amount of the assessment is determined by the homeowners association. So if the assessment is not paid by a unit owner and that owner becomes delinquent, the association may be able to enforce its collection by filing a lien against the individual unit for unpaid assessments and can actually foreclose on that unit owner's property, and if it's not resolved, can force the unit owner to sell and move. Condominium owners also are jointly and severally liable for damage or harm caused to a person or persons and property in connection with the common areas. Because each individual owner is a joint owner of the common areas, each owner is held liable. For example, suppose a visitor trips and falls as a result of a broken sidewalk area in the decking around the pool. The visitor breaks her leg. The pool area of the condominium complex is considered a common area. Because it is used by all owners, they all own it jointly. As a result, the visitor may sue all owners individually and together in order to recover damages, because the condominium owners own and control the common areas of the complex. individually and together as a whole. That's why the condo carries liability insurance to cover any such accidents, and each owner pays a portion of the premium, which would come out of part of their homeowners association assessment fees. See, that's typically why a person actually sues the corporation. Typically, they would sue the condominium itself and not the individual owners, because they understand the individual owners may or may not have money to go after, so to say. And so the liability insurance covers that, and that's where an attorney will typically file a lawsuit, is to try to recover the most amount of money for the injured party. And a liability insurance, at minimum, at a condominium is likely going to have a maximum rate or a minimum payout rate of coverage of $1 million. So as you can see, most people would not sue the individual condominium owners, but would sue the condominium itself and try to recover under the liability insurance policy, which is why it's very important to carry such a policy. This actually concludes part 2 of our lecture for the day. Tomorrow we'll finish chapter 3 and begin chapter 6. Thanks.